The first one is People versus Stephen Bieszka. It is a mini oral argument on the application. That means you each have 15 minutes. Mr. Hettinger, you'll go first, and you can try and reserve some of that for rebuttal, but we ask that you manage your own time. And with that, you may begin.
Okay, thank you, Your Honor, and good afternoon, Your Honors. What I'd like to start with is a factual statement regarding Mr. Bieszka and the occurrence that happened on August of 2015. He testified in court that there was a consensual occurrence on Friday, August 7th, between him and the complainant. She's on record for saying it was not consensual, but that's not believable, and here's why. The August incident was precipitated by both teenagers being involved in the band camp that was occurring in their school that week. And they struck a relationship, and an occurrence happened. That being August, nothing was complained about, no allegation of it being against her will was stated at that time. Then school started. Word got around with other students that there was an occurrence, a relationship between the two. It wasn't until October in a sports context, the rumors got to a higher pitch, and some students told their mothers, who told the complainant's mother, that she'd had sex with my client, Stephen Bieszka. At that time, the complainant was painted into a corner. She was a 15-year-old who was being asked about a sexual relationship. The natural thing she did was to say she was forced, and that's not true. What's telling about the reason that it's not true is explained in the text messages that are provided in the appendix of my argument. They occur willingly, in a non-forced way. In September 11th, there's conversations between her and my client about dating and the natural things high schoolers talk about. And it goes on to multiple times. In addition, she has conversation with another student, Joseph Young. In that context, they talk about losing their virginity. Not once in any of those text messages is it complained to be non-consensual.
Mr. Hettinger, let me interrupt you and see what questions my colleagues have, okay? I'm going to start with Justice Cavanagh.
I have no questions.
Justice Welch?
No questions.
Justice Zahra?
Thank you. That was a great argument, but it seems to me that's an argument that's properly placed before the trial court, who had the opportunity to see both the defendant and the victim and take their testimony. And ultimately, the trial court came to a different conclusion. Shouldn't we defer to the findings of the trial court, who had the opportunity to view the witnesses in this case?
Thank you, Your Honor. I think that's the general rule, but in this case, it's illogical that the complainant would engage in meaningful textual communications with someone who had sexually assaulted her. So it just doesn't make sense. That was pointed out to the trial court, and they passed over that decision, which I think is why there's clear error in the matter.
But isn't it fair to say, as the Court of Appeals noted, that the texts show perhaps a romantic and consensual relationship, but it doesn't prove that every encounter was so?
That's not a natural conclusion. They do show that a romantic relationship occurred, but telling is that it's after the alleged occurrence. I think it's illogical to believe that the romantic relationship would continue in a normal vein after violent sexual assault, such as described in the preliminary exam transcript and the letter at the Zahra hearing.
Thank you.
Thank you, Your Honor.
Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Hi, counsel. Good morning. If I could, I just wanted to ask and just expand a little bit on what Justice Zahra asked, which is, when we're trying to understand this, again, is this the question? I guess I'm trying to apply this to the Supreme Court versus the trial court. And I appreciate your answer. I'm just going to give you a second opportunity to perhaps maybe expand upon your answer.
Thank you, Your Honor. In this case, I think it's important to note that the text messages were presented to the trial court, but they passed over giving any significance to them, which is where I believe the error is occurring. Thank you, Your Honor.
Okay, thank you.
Justice Clement.
No questions, thank you.
Counsel, you have some additional time if you choose to use it, or you can reserve some of it for rebuttal.
I'll reserve. Thank you, Your Honor.
Thank you very much. Ms. Beidler.
Good afternoon, Your Honors. Meredith Beidler on behalf of the people with the Prosecutor's Office for Allegan County. The court asked us to discuss two very distinct questions. First, whether the trial court erred when it determined that the defendant didn't meet his burden of proving beyond a preponderance of the evidence that the victim consented to the sexual act in question. Brother counsel points out these text messages between the victim and the defendant, as noted by the Court of Appeals and a couple of justices today. Those text messages do nothing more than establish a romantic relationship. And not every sexual encounter within a romantic relationship is automatically consensual. The majority of these text messages took place about a month after the sexual encounter in question. And in those text messages, the victim states, when talking about the relationship, it's illegal and my parents wouldn't let me and I need to earn their trust. To which the defendant responds, the relationship itself isn't illegal, it is having sex. That's illegal. Now, notably, the victim doesn't even acknowledge a sexual encounter during these text messages, and they're very vague and far removed from the event. It's not clear that they're talking about any one particular sexual encounter. It's possible that the parties engaged in sexual encounters prior to or after the August 7th event that were consensual. Furthermore, as I outlined in my brief, the victim wrote a letter to the trial court where she described some of the defendant's actions after the sexual encounter took place, how he would pace behind her doorway at school, how he threatened her sister. So it's not unusual that she would continue texting him. She was probably afraid of what he would do if she stopped the text messages. They don't actually establish that they had a consensual sexual relationship on August 7, 2015. And regarding the text messages to her friend, she just indicates that her and the defendant broke up, and she states that she lost her virginity, but she doesn't say who she lost her virginity to, and she doesn't say that it was consensual. None of the text messages that the defendant provided established that that act on August 7, 2015 was consensual. And unlike the premise posed by the defendant, the existence of a romantic relationship doesn't automatically mean every sexual encounter within that relationship is consensual. Additionally, the defendant's suggestion that the victim changed her story as soon as her parents found out is nothing more than a theory. The only evidence that the defendant provided to support this theory is that his own father heard the victim's mother say that the dad had a bad temper. That's pretty far removed and suggestive, and there's no other indication whatsoever that the victim's depiction of the event was influenced by her parents. It's just the defendant's theory, and it's not compounded by any real proof here. I might also like to just address the defendant's contention in the brief that the Court of Appeals is trying to come up with some type of affirmative consent law here, or a yes means yes law. I really think that's a red herring here. It's very clear that the victim in this case did not consent to these acts. She said in her letter, I asked him to stop several times and he didn't. So the appellate court is not trying to create an affirmative consent law here. Their ruling simply acknowledges that the victim told him to stop and he didn't, and the defendant utterly failed to meet his burden to prove by a preponderance of the evidence that the victim consented to the sexual act in question. So when you take the evidence, the conflicting evidence here of the victim and that letter and her testimony at the preliminary examination hearing and weigh it against these vague text messages and the defendant's father's testimony, the defendant's side is just not more convincing, or does it have the greater probability of the truth as required by the preponderance of the evidence standard? So when you review,
Let me interrupt you and see what questions my colleagues have. Thank you very much.
Thank you.
Justice Cavanagh.
I have none.
Justice Welch.
No questions. Thank you.
Justice Zahra.
No questions. Thank you very much.
Justice Viviano.
No questions.
Justice Bernstein.
No questions at this time. Thank you.
Justice Clement.
No questions.
Okay, no questions, so you may proceed if you would like.
Thank you. I just wanted to conclude that section of my argument by saying it was not clear error on the trial court's part to determine that the defendant didn't meet his burden to prove by a preponderance of the evidence that the victim consented. The court has also asked us to address whether a 14-year-old can consent in any event. It's well established in Michigan that the age of consent is 16 for sexual encounters, but that doesn't preclude the legislator from making a 14-year-old's factual consent relevant for other things, such as SORA registration. As I mentioned in my brief, the age of consent laws that I did research on, the primary goal of those is to protect minors from predatory conduct, primarily from adults. However, MCL 28.728C, parents 14, or the Romeo and Juliet statute, as most people refer to it as, that was enacted to protect minors as well, to protect minors from having to register on SORA for the rest of their lives for an act that was probably, or if they could prove it, factually consensual. Further, the statute simply allows for leniency in sentencing. It doesn't necessarily mean that the underlying conduct was not illegal. It simply is a mitigating factor when it comes to sentencing. Thus, while a 14-year-old may not be able to consent legally, as this was drafted throughout the PAM's amicus brief, they can consent factually, and that can and should be considered relevant for purposes of SORA registration or leniency in sentencing. I'd like to conclude by posing, if the SORA statute was enacted to protect minors from predators, then should we label teenagers who engage in otherwise factually consensual sexual relationship as predators? If there are no further questions, I would rely on my brief, and I ask that the court deny leave on this application.
Thank you, counsel. Mr. Hettinger, you have some rebuttal time if you care to use it.
Thank you, Your Honor. The text messages aren't vague. They're conversations that are very specific that go on regarding a relationship that the plaintiff has with my client. And I'd just like to underscore that it's illogical to believe that those conversations by text would be occurring if the complainant had actually been a victim of a crime. Thank you.
Thank you both. The case will be submitted.